Well, good morning, Chairman Hughes. Thank you for having us and committee members. My name is Chelsea Youman, and I'm the National Director of Public Policy for Human Coalition. I also have a background in practicing constitutional law, and I'm here today to testify in support of SB31. While debate around abortion is fraught with disagreement, my hope today is that we can coalesce around agreeing that unborn children in the womb and their mothers need and require medical care in emergency situations. The purpose of today's conversation should not be to relitigate Texas' commitment to protecting children in the womb and the mothers who carry them, but to recognize real progress that this legislature and Texas courts have made towards clarifying the law around life-saving cares for mothers facing tragic emergencies. To be clear, Texas law allows women facing dire medical emergencies to retrieve medical treatment when they need it, and not when they are, to quote John here, at death's door. Texas pro-life laws protected women in medical emergency situations before, during, and after the Roe regime. And not just because the legislature cares about pregnant women, which they do, but because the United States Supreme Court required it under Doe versus Bolton. But since the Dobbs decision was overturned, the Human Life Protection Act was enacted, and this created a serious confusion, if not fear, in the medical community around how and when they can treat women facing really horrific complications during their pregnancies. The first to provide clarity was actually the Office of the Attorney General in June of 2022. He issued guidance clarifying that yes, the state of Texas will protect unborn children from death by abortion, but also their mothers, and he clarified the exemptions around life-threatening emergency situations. Unfortunately, in practice, doctors and their hospital administrators responded to the overturn with Roe with fear. And as Dr. Ingrid Skopp, who's an OBGYN out of San Antonio and the vice president of the Lozier Institute, said, intervention, not neglect, should be the standard of care. Many in the medical community called upon the Texas Health Department, Texas Medical Board, and Texas Medical Association to ward off these dangerous situations by educating and providing guidance to doctors and hospitals. You may recall, Chair, you were one of those voices as you drafted a letter in 2022 requesting that the Texas Medical Board clarify the standard of care under Texas law. Instead of doing so, they declined and it ultimately became a defendant in the Zorowski case, which challenged pro-life laws on the grounds of these medical emergencies. You will also recall that this body in 2023 further clarified the laws by passing a bipartisan bill, House Bill 3058, which clarified that treatment for ectopic pregnancies and premature rupture of membranes, or PPROM, is fully protected under Texas law. Yet, Texas doctors, perhaps at the direction of their hospital administrators, would not treat women. The Texas Supreme Court also provided clarity on the state of the law to protect women facing medical emergencies in Texas, not once but twice in 2023 and 2024 with two high-profile cases. In those cases, in the court's words, the law permits intervention before death or serious physical impairment are imminent, and the court emphasized that the doctor's reasonable medical judgment is what governs if or when an abortion may be necessary to protect the life of the mother. Finally, the medical community weighed in last year. The Texas Supreme Court requested the Texas Medical Board to issue the guidance, which they ultimately did. Which leads us to today. We are so appreciative that yet again, this Texas legislative body is considering clarifying the law even more. SB 31, I think most importantly, provides education and guidance and continuing educations to doctors who are treating pregnant women in need. Most notably, in the 2 years since Roe was overturned, not a single doctor, although dozens of women have received abortion in the state of Texas, for tragic complications during their pregnancies. Notably, none of those doctors have been charged or prosecuted. This law further clarifies and insulates what has already been affirmed as the standard of care by the Texas Supreme Court. Thank you.